Hi, and thanks for joining me for another episode of Legal Q&A. I'm your host, Peter Lamont, and this is UTLradio.com, your business success and legal information station. Today I'm going to be answering a question: how do you request a new court date when you're representing yourself and the court assigns an arbitrary court date to you? But before I begin, I want to thank today's sponsor. Are you starting a new business and don't know where to begin? Well, check out MyLaunchKits.com. MyLaunchKits.com is your mission control for launching your online business. With reliable hosting, affordable design, and expert customer service, MyLaunchKits.com wants to help you launch your website. From small personal sites to large e-commerce stores, MyLaunchKits.com does it all. And their team of client support specialists are always on hand to help answer your questions and help you out. Come experience world-class service and affordable rates with MyLaunchKits.com. Boost your business potential. So thanks to MyLaunchKits.com for sponsoring today's show. Now let's get into the question. So if you're representing yourself and you're in litigation and end up having to go to court, you are going to receive a notice from the court about a hearing or a motion date or a trial date. And oftentimes when you get that notice, it might have a date where you have something going on. Maybe you're picking your kids up from school and you don't have anybody to watch them. Maybe something else, you have a surgery planned, or whatever it is, you just can't make that date. And you need to ask the court for more time or a different date. How do you do that? What's the proper procedure? Well, the proper procedure is to write a letter to the court and explain to them that you're the plaintiff or defendant, whatever you are, in the current matter. Make sure you identify the matter and either the docket or case number. That's the identifying number that lets the court know what case you're referring to and the name of the case so that they know exactly what this correspondence is about. Don't just send a letter and expect them to know. You should always include the docket or case number and the name of the case. And then explain that you received a court notice letting you know that there is a conference or a hearing scheduled for, and whatever the date is. And then explain that you cannot make that date and give the explanation. I mean, the courts are pretty lenient, especially with pro se litigants, if you can't make the date that the court sets for you. But again, don't give some ridiculous answer or reason why you're not going to be able to make the court assigned date. Like, don't say something like, there was a movie I'm going to, or there's a show on TV that I want to watch. Don't give them some stupid answer or stupid reason, because then they're going to just say no, too bad. But if you give a realistic reason and a quality explanation in your letter about why you can't make that hearing date or that conference date, the courts are generally lenient and they'll give you a new date. Now, in addition to sending that letter to the court, you are going to want to send that letter to your adversary as well. Because when you're communicating with the court, in most instances, there are some times when maybe you don't send something to your adversary. Perhaps the judge has instructed you to put together some formal statement and they've directed you not to disclose it. But in general, if you're going to communicate with the court, you should copy your adversary. So that letter that you send to the court requesting the adjournment, which is essentially a new date, adjourning this hearing or conference and putting it on a new date, you should copy your adversary. Now, I would also recommend that you follow up that letter with a telephone call. Sometimes things get lost, and just because it's a court or a judge doesn't mean that mail errors don't occur, the dog ate your adjournment letter, whatever it might be. So I would really recommend that you call the court maybe a day or two or three or four before the hearing date and say, I just want to make sure that you guys received my request for an adjournment or my letter asking for a new court date. Do you know if the judge has seen that or if a new court date has been assigned? And then that way, you're good to go. You're not going to end up thinking you sent a letter in and that they received it and everything's okay, and then you get a nasty call or worse, some sort of bad thing happens with your motion or your hearing because you don't show up. And when you go back to the court and say, Judge, I sent you a letter and I assumed you got it, they're going to be irritated, to say the least. So by making that follow-up phone call, you're going to know for certain that they got your letter and that your hearing or conference or whatever has been move to a different date. So that's really the best way to go about requesting a new court date. Well, thanks for joining me for this episode of Legal Q&A. Don't forget to check out utlradio.com for more business and legal information. If you have questions that you'd like answered, please contact us. You can go to utlradio.com, find the email address, find links to our social media, and there's a great feature on the site where you can just use your computer and log in to a website and ask your question, and your voice will be recorded and we get the question. So if you've got specific questions that you'd like to see answered on one of our episodes, please feel free to submit them. That's what we're here for. We're here to answer your questions. So thanks for tuning in. Don't forget to subscribe to the channel, and we'll see you next time.